Hi, everybody. Matt Johnson again, counsel for the New Hampshire Realtors, with a quick legal reminder there with some legislation changing, particularly relative to accessory dwelling units and some of the resource line questions and calls I've received. I wanted to remind everybody that there is a distinction between what I would say is public law. Those are statutes passed by the legislature, signed by the governor, and private law. And that can be either restrictions in a deed or homeowners association or condo association declaration or rules. And why I bring that up is that for certain things where there might be generally permitted publicly, that, for example, the new ADU statute or maybe short-term rentals by zoning, the fact that either an ADU is permitted by state law or perhaps your town zoning allows short-term rentals, you still have to look at any private deed restrictions or private condominium association or homeowner association rules that are in place. Because if the private rules restrict that conduct, the statute or the zoning does not override those private rules. Those private rules are going to be enforced and enforceable. So make sure you do your due diligence. If you have a client that these issues are important, make sure that property is not subject to private restrictions that would otherwise prohibit that type of conduct. And remember, if you get into that and it gets a little tricky, make sure you advise your clients to go seek legal counsel and get a legal opinion on those issues before you move forward.